All right. Good evening, everyone. Thank you all for coming. My name is Todd Brous. I'm here with my co-founder, Susan Schultz, and we would like to welcome everyone to HBAP Startups. So let's get started. First off, for those of you who are new to the Startups group, we have a few announcements at the beginning of each meeting. We'll do some short networking breakout rooms, and then we'll come back together for our main event. And first off is our mission. We're here to help foster and fortify an innovation and entrepreneur community coming out of the Harvard Business Analytics program. And our goal is to provide our members with the tools, knowledge, leadership, and confidence necessary to create and grow their businesses from the ground up. And you're probably wondering how to engage with us. I'm going to put a bunch of links into the Zoom chat. Bear with me for a second, that you can click on to sign up for our newsletter. Check out our website. Also, please check out our YouTube channel and like and subscribe to the videos that we put there. All right. And Susan.
Yes. So in order to drive and foster that kind of environment, one of inclusivity and collaboration, just a reminder to everybody that all rights are reserved by the presenter unless they specify otherwise. And of course, we follow the honor codes of Harvard and the feedback approach of Frances Fry, who has a relatively new TED Talk up now, which is just incredible about being authentic. And her feedback approach is for every one piece of tart feedback, give 5 pieces of sweet and optimistic feedback, because that works better for humans. And that's been modified by our own Kelly to say, just skip the tart feedback entirely and focus on positive feedback. And then always, if there's a worry about anything that you want to bring up or talk about or think about with us, and you feel like there might be a conflict of interest or a confidentiality issue, just reach out to Todd and me and we'll help you figure it out.
Next slide, right? Okay. So Susan, let's call, we had a new guest here. So Manav, I'm cold calling on you. Please give us a 10-second introduction. Who are you? Where are you from? What do you do? And how did you hear about us? And what's your superpower?
Hi. I guess this is my second 10-second introduction.
Second time. I'm sorry.
But my name is Manav. I was invited as a guest by Manian. And who am I? I'm a student. I study computer science, business analytics, and statistics. I'm from North Carolina. What do? I'm actually working on my own startup called Relio. And how did you hear about us? Mani invited me, and my superpower, if I had a really good superpower, it would be making the best ice cream.
Ooh,
that's a worthwhile superpower.
That's a good superpower.
Yeah. What is your favorite flavor of ice creams you've made?
Well, the last time I made ice cream was back in like kindergarten, and that was vanilla, but I really loved it then.
Love it.
Awesome. All right. So just to go over what's upcoming, right? Tonight we have Cynthia Gilbert talking to us about protecting intellectual property, especially with AI and tech material and companies. And I have worked personally with Cynthia. It's going to be fun to hear from her. My eyes were completely open and my brain was blown away by the kind of things we need to be thinking about. Then for July, our monthly social, and then Phil Morris, who is an actor who played Jackie Childs on Seinfeld, and he's going to be talking to us about the entrepreneurship of acting. Really, really cool. And thank you, Kelly, for bringing him on board. Then on the 19th, we're going to have a generative AI workshop, and more to come on that, but that's going to be really fun. Some hands-on use of generative AI, and maybe around branding, maybe around going to market, but it'll be a workshop not to miss. And then on the 26th, we have, again, the honor of Congressman Jimmy Gomez from California talking to us about the complexities of regulating AI. And I think we're going to hear a little bit about that tonight from Cynthia, but a lot more from Jimmy Gomez on the 26th. you can imagine what the complexities are. So a really good lineup, not to be missed.
Awesome. Thanks, Susan. All right, so let's do some social breakout rooms. Talk amongst yourselves. We'll see you guys in about 5-6 minutes. Zoom recording.
There's all these advancements.
Yep, it's incredible. All right,
Thomas, you got hit with the latest advancements. I mean, all this continuation camera. When we first met, you had this crazy rig and all this stuff. Now the best camera you have is your iPhone.
Yeah.
Done.
All right, well, we'll pick up on that later, Lucas. All right. I hope everyone had a good time in your breakout rooms. Let's reminder, lost my train of thought. Please, when we're done with Zoom tonight, please fill out the survey when you exit Zoom. The surveys really help us. We're analytics humans, and without data, we become distraught, sad, lonely, and depressed. So remember, data scientists love pie charts because they're delicious, and everyone likes pie. And after we're done, we'll stop recording. We'll go into a little bit overtime, and just a reminder again, this will be made public on YouTube. And now.
Hey, but hang on, sorry, before you go. So please do the survey, even if you only fill out the part that says, I'd like to hear more about, because what Todd and I do quite a bit is we look to what your surveys say to look at, like, what other kinds of speakers should we bring in? What kinds of workshops might you all want to do? So please just fill out that part. Anything that you think would be cool to learn about or cool to have a hands-on workshop about, just type some words in there, because that really helps us. Okay, and now without further ado.
Sorry. Thanks, Susan. Tonight is my honor to introduce tonight's guest speaker, Cynthia Gilbert. Cynthia is a software patent lawyer and founding partner at Blueshift IP. Cynthia has developed deep experience across a wide range of technology disciplines, including virtualization, cryptography, network security, artificial intelligence, machine learning, natural language processing, computer vision, large language models, cloud computing, mobile technologies, operating systems, and communications infrastructure. She's worked for clients ranging from the smallest startups to billion-dollar companies, and brings a lifelong passion for technology to her work with every client. In 2020, Cynthia was named an IP trailblazer by the National Law Journal, putting her in an elite group of IP attorneys nationwide. And for the past 3 years straight, American law media has recognized Ms. Gilbert as a woman leader in law. Cynthia is a Massachusetts super lawyer, and she's been in the top women's attorneys in Massachusetts list that includes a special section in the Boston Magazine several times. She's been in that. And I haven't even started talking about her community involvement, and I'm just going to skip it all. So now, without further ado, as is our custom here, if we could all please briefly unmute ourselves, and let's give a warm round of applause to Cynthia Gilbert. We didn't unmute. We failed on the unmuting side. Okay, Cynthia.
Sorry.
Well, it's delightful to be here with you all. I think everything that was just said really could be boiled down to I'm a huge geek, and I found the geekiest area of law to specialize in. And you were talking about superpowers earlier. I really try to do a lot of translation. I think that would be my superpower. I translate between geek and business, between geek and business and law, Spanish to English, not usually that helpful in the tech space, but really translating between what's the vision and how are we going to get there? What are we going to actually accomplish? Translating between the patent law ivory tower and real world budgets and constraints. And so translation and geekiness, that's the hallmark here. I started life as a computer scientist and became a technologist at GTE, which is now Verizon, helping them figure out how do we keep our cell phone data secure, which of course they promptly gave up on. And I loved technology. I loved being a white hat hacker. I loved all of that. And I thought, but surely there's something more interesting where I can have a more immediate impact on people's lives. And so I became a patent attorney. I've worked at middle-sized firms, giant firms. I've been a solo practitioner. I'm now at a 2-attorney firm based out of Kendall Square. And the goal is always to help people not just understand the patent space, but understand what it means for their business, be very pragmatic about how do we approach this on the business side. And I am delighted to get to speak with you all tonight. I hope we can keep this interactive. I will try to keep an eye out in the chats if we can ask questions, at least here on the East Coast. I don't know where you all are physically, but it's getting late. Try not to put anybody to sleep here. And I thought I would start with just a super quick introduction to the different kinds of intellectual property before we dive into my favorite kind. I'm sure you've all heard there's copyright, there's trademarks, there's trade secrets, there are patents. These words are all probably very familiar to you. I always think of going to get a cup of coffee at Starbucks or Dunkin' Donuts, and I'm given a little cardboard sleeve. And that little sleeve has all three of the major types of intellectual property right there. So it says in some clever, creative ways, we have crafted this beverage for you. Be careful, the beverage you're about to enjoy is extremely hot. The exact phrasing of that is copyright. Copyright is delightful. You get it instantly. It is free. You don't have to do anything to get it. It's also really easy to work around. And so we phrase things slightly differently. And now we can also say that my coffee is going to be extremely hot. Don't spill it on yourself. And I'm not infringing anybody's copyrights. Romeo and Juliet, totally different from West Side Story. Different people dying in different parts of the world with different weapons, different methods of death, different kinds of side drama between the nurse and the best friend. So copyright can be useful, but it's often more useful outside of technology. It's more useful for singer-songwriters, for people doing TV, all the things they do in New York and California that are not technology. And as a belt and suspenders kind of thing. If you had the time, sure, why not go think about what version of your code you ought to upload to the Library of Congress and decide if that's a smart thing to do or not. Going back to my little coffee cup and my cardboard sleeve there, it also has a trademark on it. It's got a thing that instantly tells me where I got that cup of coffee. And it's got, it's a green and white mermaid-ish kind of a figure, or it's two letters D in different colors. I see somebody walking down the street with holding one of these things. I instantly know where they went. I make all these snap judgments about them. I make all these decisions based on what I see, and I know the company behind that. And there are all kinds of trademarks. There are trademarks on the sound that a Harley Davidson engine makes when you rev it. There's trademarks on the smell of Play-Doh when you open the jar. The Pillsbury Doughboy giggling, like that's a thing. So people spend a lot of money on this. Plenty of women get very excited about the shade of blue of the box under the Christmas tree, or the different kinds of jewelry that's out there. Perfumes have a lot of very specific names. Anything that makes you think of a particular company and say, I want to give them my money and not somebody else, that's a trademark. Often it is very easy to get a trademark. You just have to say, hey, I've been using this in business, give it to me. And the Patent and Trademark Office will make you say, okay, well, which business? Like, were you using Blueshift IP in litigation? Were you using it in patent law? Were you using it in technology and astrophysics? Because you've got this whole Blueshift word there. What is it that you're using it in? There's some back and forth, but you can usually get your trademark in about a year and a half, probably less, and you can do it at any time without losing significant rights, usually. So those are great, but it doesn't actually tell you anything about the underlying product. People could call it something else, they could describe it in a different way, and they could still use your underlying product. And so that's where patents come in. And again, thinking of my coffee cup sleeve, if you flip one of those on the side and look at it, it's usually got 2 layers of cardboard and then little corrugated triangles going all the way around. There's actually a ton of patents going back to the early 90s on those things. How thick the cardboard is, how densely packed the triangles are, how corrugated is corrugated, is it 1 layer of cardboard or 2? All of that works to dissipate heat away from the human hand at a different rate, which is what we're going for. And that's the invention. It's not just a little bit of cardboard. It's something that is heat dissipation technology. call it whatever you want, but there are dozens and dozens of patents on these things. And it doesn't matter what label you put on it or what company it makes you think of. If you are making it in a certain way, you might be infringing one of those patents. So that, I think, is sort of the easiest cheat sheet in terms of what are the different kinds and what are we getting them out of them and why would we do it? I see a question on when is the right time to loop in an attorney. And I often say it's never too early, but it is often too late. And in part, it's because you don't necessarily know, should I be getting a trademark or a copyright or a patent? What in my industry is the right thing? A lot of people in ed tech, they're off trying to save teachers' lives and make it easier for them to go educate everybody. They're not necessarily looking to block competitors. They're not necessarily looking to be remembered for it. They just want to put it out there. They'd like a little credit, maybe they want a copyright. Great, free, easy, they're done. But they don't necessarily know which of those 3 or possibly 4 or 5 other things did I want? What did I actually need for my business? And so in some areas, it can get to a point where it's too late. I was a little flippant with trademarks when I said it doesn't really matter. Certainly, I would have been crushed if after handing out 6 months of business cards that said Blueshift IP with my happy little logo on it, I learned that either there was another Blueshift IP in the patent practice area, and I had to change my name and hand out those cards all over again. Or if somebody was passing those cards out pretending that they were me and they said, oh, but we didn't use color, it's totally different. And I had to go out and figure out how to stop them from passing themselves off as me. So depending on your industry, it can matter a little bit if you've been using it, if you have the right to the name, did somebody else get the name? So it's not necessarily going to be too late. It's more of a question of annoyance. How hard will it be to change your name at a certain point? For patents, though, the hardest, most challenging, most expensive and slowest kind of IP to get, there are extra challenges in that the patent office says, actually, we're going to restrict the time at which you can file for your invention's patent application. So they say, look, the whole point of this is that we're going to give you this huge monopoly, 20 years to tell other people to cut that out without anybody being able to stop you. But in exchange, you're supposed to give us something. You're supposed to tell us how we do this. You're supposed to say something other than, and then there's a black box and there's a secret sauce and the magic happens. You're supposed to make it so that somebody in theory could read a patent. Again, in theory, I don't know who this person of ordinary skill in the art that can read a patent is and figure out how to turn that into technology. But the swap is supposed to be, you tell us how we do the magical thing you've invented. We'll give you 20 years of blocking other people from doing that exact same thing. And so in that case, it can be too late. And it can be that, well, because you were supposed to tell us, if you already went ahead and told everybody, you released the product, you did a live stream event and told everyone how amazing it is, you tweeted or blogged or podcasted or whatever people do, you went to the 4th of July party and told all your best friends and neighbors and competitors and everybody about the secret sauce, the patent office in the US will say, gee, sorry, you don't get to have a patent anymore. Why should we give you a monopoly? You already told everybody how it works. What's in it for us? Internationally, they are a little bit more, we'll call it fair. They say, well, you can't have just mentioned it over hot dogs on Tuesday. You have to actually have said a lot about what that innovation is. You have to describe the invention and really made it so somebody listening to you would know how to implement that. And because we're being so fair, if you actually make the mistake of doing that, you instantly lose your right to file in over 154 countries around the world. Lucky you. Look how gracious we are. So those are things that you can work around. You can make decisions. Maybe you didn't want to file in 154 countries around the world. Maybe you're doing AI for analyzing Social Security, Medicare, and Medicaid claims, and this is really very US specific, and it's fine that you blew the deadline for filing internationally. But most people don't want to have to figure that out after the fact. They would rather very intentionally write off international filings as a very sound strategic plan than have to say, we blew the date. So that's why that's a very long-winded way of saying, please talk to a lawyer as soon as you can. Most of us will tell you whether or not you actually need us or not. most of us will tell you, no, you don't need us yet. Go off and code and be happy, or yeah, you're too late, or we should start working right away. So that I think does bring up this question of wait, you just gave us this huge reality check and told us patents take a long time to get. They're expensive, they're annoying. There's all these things we could do to lose all these rights. Why are we going through that again? And copyrights were so free, right? That sounded so good, free. It always sounds so compelling. We are often in a place where we are trying to think long-term. We are trying to think not just about the product as it exists today, but as it will be. For patents, we're thinking over a 20-year term. And so the question is often, what do you envision for your product, for your invention, for your company? What do you envision? It often sounds a little cheesy. Do some soul searching. What's your exit? Do you want to get acquired by Google, IBM, all of the big people that people dream about getting acquired by? Do you want to give it away for free to educators? Do you want to do open source? Thinking about what you actually want to have as an outcome will help you answer the question, should I go through all of that bother? A lot of times the answer is, I don't know yet. I need more time. And there's an application for that. And we can file a kind of patent application that buys you some more time and gives you a year to determine what your options are. But again, you have to have thought that through before you started buying, selling, trading, telling people about your innovation. A big factor for most early stage companies is the signaling value. If you have a pitch to a acquirer, investor, a partner, anybody who's super excited about your product, but could probably also like turn against you if things go south, you may want some kind of protection. And you may also want them to think of you as a peer, as somebody that should be at the same table with them and being treated with respect, and not just somebody they can rip off the minute you walk out. And often a patent application tells them, you have some resources. You have the ability to find people outside of your company who you've managed to convince you actually have an invention here. You've thought through, you didn't just file 100 patents in 100 different countries. You thought through what your strategy was going to be. And you were able to come to them with, especially investors, they almost don't care what the answer is. They just want to know you thought it through. They want to hear, we have 3 features that really distinguish us from everyone else in the market. This is the hook. This is the piece that makes us really unique. And that's why we filed 2 patent applications in the US. We may possibly file in the Europe and Canada. We'll let you know about that one in a year and a half. They would also rather hear, we've realized that our real differentiator here is the team and the approach we're taking in terms of how we're going to, close the sales leads and how we're going to market this, and that we're just like a lot of the companies out there, but our fundamental people approach is different. And so we didn't file any patents. That's fine too, but they want to know you have really rigorously thought this through. And that is true no matter what area you're innovating in, whether it's got AI in it or not, any area of technology. Being smart about why you do or don't patent is very important. The other thing is that you might actually really succeed. You might take off. You might end up having a ton of money. You might end up eating somebody else's market share, and they're going to get super annoyed and want to do a deal or, squash you. Either way, having more tools in your arsenal will be helpful. And it is always easy when you have gotten to be big and successful to say, I have hundreds of patents, I don't really need them anymore. I'm going to let everybody have them. But if you didn't have those patents, you may or may not have gotten to the stage of being big and successful. And so it is always better to think through, what do I want in the short term? What do I think this patent might do for me in, a year and a half, in 2.5 years? 5 years, 10 years, nobody knows that stuff. That's, it's really impossible to figure out where you're going to be. But at each point in the process, to try it and think through what's the next right decision, it makes a big difference on your IP strategy. I also think that all of the questions that a good patent attorney asks you are useful on the business side as well. Somebody asks you, have you actually tried this out with actual doctors? Mr. or Ms. Digital Health Company, have you tried this out with actual patients? Have you tried to get reimbursed for that? Have you tried to think about what the privacy regulations are going to require of all of that data? Having someone ask those questions on the innovation side often is something that if you haven't already thought about it on the business side, you should. So those are some of the benefits. Obviously, you ask a patent attorney. I think patents are a good thing, so maybe take it with a grain of salt. But I do want to make sure we have enough time to talk through the AI piece of this. And to start with, I'll say, to have something that's patentable, you've got to have something new. It's got to be useful, and it can't be obvious. New is super easy. You wouldn't be doing this if you could download it already for 99 cents on the App Store. It wouldn't, if you could have just Googled it, it would be fine. You could go do something else with your life. Useful, super easy. If somebody else will pay 99 cents for it on the App Store, it's probably useful. And in the non-software spaces, in physical devices, people often say, if you can throw it at a plant and the plant lives, it's clearly some kind of fertilizer. And if the plant dies, it's clearly some kind of pesticide. Perfect. Some kind of, it's going to be useful. That's never the one people are worried about. Obviousness is the real challenge, and especially in technology. And again, I think, philosophically, this comes from a really important place. Nobody here would say, you know what we ought to patent tonight? Spreadsheets, man, that is amazing. Think of all of the paper and pencil, all those old accountants went through when they could have just used a computer. But at some point, spreadsheets were actually novel, and being able to use technology in the way we do now without even thinking about it was actually novel. So the patent office really struggles, and this is because the law is this slow, molasses-like ooze trying to keep up with novel new technology. And by definition, we're dealing in a space where things shouldn't or don't already exist. And so it's hard to create legislation that matches the pace of technology. And that's kind of the whole point of the patent office, like forever, since way before we had to try to figure out what spreadsheet technology we're going to use. And we're going to use RStudio or Excel. People have been worrying about this for a long time. Has everything useful been patented? I think it has. We should shut down the patent office, is what the Romans said a couple millennia ago. So I think that this obviousness question comes from a good place. I'm in software patents. I deal with a lot of people who don't think we should even have software patents and have a strong philosophical bent against them, which is fine. If we were all to come together tonight and recreate the entire universe from the beginning of time, I'm sure we'd come up with a better patent system. I'm sure we'd come up with a better way of dealing with software and how we're going to protect or not protect it. But we're not doing that tonight. And my goal is always to help my clients function in the world as it actually exists, and to translate between what you wish happened and how that's going to play out in the actual business world that we're all operating in. So we're stuck with the system. We got to figure out this obviousness thing. And there are two pieces of the question, like I said earlier. The nicest, the most objective piece of this says, if we searched everywhere on the planet, would we find out that somebody had already done this? If we checked all of the YouTube recordings and all of the websites and all of the patent offices and every, rock in Australia, would we find that someone had already done this? And if we found a couple of things we could cobble together that made it pretty reasonable to think this was an obvious extension, like in all the long history of geeks in dark windowless computer labs, why didn't anybody think of this? Look at all the technology we have. Well, really? You've got some kind of AI? Nobody's actually got this before? People have been saying AI is 20 years away for 20 years. And I heard that 20 years ago. Like, come on, surely someone has come up with what you're doing. And that's very objective because we can find out. We can look at the material and say, actually, no, I've read 3,000 pages of patents this week, and none of them talked about feature number 114 on this guy's list. So that's what we're going to go patent. The other piece is a little harder, and it is a reflection of how the patent office struggles to keep up with what we're doing. And they say, well, some kinds of technology are so well known that it's just not eligible for a patent. The subject matter is just not eligible. And a big rejection people see, especially in AI, is, you're taking a document, you're taking some data, and you're giving it to a box, which is going to apply some rules and give you some outputs. That's been done. That's what people do all the time. That's what computers do. What did you come up with? And this is hard because I actually had a patent where I said to the client, what is the minimum set of iterations you would have to go over this data set that you would just think everyone in business has to do it this many times? And they said 25. And I said, great. So I went to the patent office and I said, the method of claim 1, wherein we repeat steps 1 to 9 25 times. Done. We got a patent. They were pretty confident that all of their competitors need to do this at least 25 times. All of them will infringe this patent. There's no way of doing it in less than that number of steps. That, I think, is ridiculous from a philosophical perspective. As a person with a brain and lots of opinions, I think that's a stupid way of running a patent office. But again, focused on what we're actually dealing with, that's where we're at. The patent office wants to know, what is it about this technology that's different? And luckily, we knew this was coming. We knew this was going to be a challenge. And we had paragraph 72 that said, we actually wrote out how long it would take for a human to do all of these calculations and how long that would take. And given their business needs of having things done in less than an hour, it was just impossible. So we wrote it down. And we had the protection in there. We didn't start with that. Of course, we started with broader claims. So when the patent office came back to us and said, you've got to narrow it down, we said, all right, we've already thought about this. Here's the answer. And I think that is the benefit of starting with an attorney from the very beginning, because you can say, I'm not just making this up. I had support for this in the application going back, 2.5 years. And really thinking through what are the things that we're going to need to write to keep the patent office happy, and knowing that these questions are out there. Like, I don't think most startups really think, but what if we tried to do this with pen and paper, right? Most people in technology, certainly most people in AI, no one thinks, I think we're going to compete against people that are doing this with pen and paper. It's so clear to us that you wouldn't do that. So there's a question here about strategy, and often what we try to do if we're working from the beginning and we have plenty of time to do things properly is create both a definition of the invention that covers it at its broadest, covers it in each of the major use cases you might want to license it out for, and then also has some backstops, some narrowing limitations we could add in that aren't actually that narrowing, that where we've had that conversation. If we add this in to keep the patent office happy, will your competitors just be able to work around it? So obviously a counter example to that one would be, I know, we'll say step 5, all of our servers have to be painted fuchsia. And the patent office will be like, all right, you got me. I can't find anything that says they've got to be painted fuchsia. Here's your patent. And then all of our competitors will go out and get servers that are mauve or lilac or standard gray and not infringe your patent. So we want to keep this balance between keeping the patent office happy and still being useful in the real world. And this is an area where a lot of AI companies really struggle, because we are dealing with some pretty dumb rejections that come from a well-intentioned place, but they say things like, well, why would you use a large language model instead of pencil and paper? And so that, I think, is probably the biggest challenge that AI faces. And I think there's 2 ways out of it. One is to try to decide, are we the kind of company that's actually going to go into the black box and pry off the lid and get in there with our weights and all of our little neural networks and really reconfigure how this works at a core? We are actually redefining what it means to have, semantic meaning analyzed out of this corpus of documents, or we're really focused on how we're going to make the large language model couple up with 3 other kinds of machine learning networks in a very different way than people usually use these technologies. The other approach is to say, okay, fine, you win. All we've done is taken our data and fed it to a computer that applied some rules and we got some output. But then we did all this other stuff. Then as a result of being able to say, all of this output is now labeled in this way, or we now have access to statistics about some piece of information that wasn't able to be found before. Well, now we can, page somebody or send an alert or change how data is stored somewhere or create a report or a recommendation, or we can do something. And that is often the piece that you're going to be selling. So again, with the questions we're asking here, tie back into your business. The clients, your clients probably don't care too much about what's going on in the black box. They want to hear, now all of these things will happen better, faster, cooler, and we get access to these new features we didn't have before. So we tie those other features in to be able to come up with a system that is innovative, even if we have to concede we didn't actually invent AI, right? We didn't actually come up with that model. And so those are the two general approaches that people take when they're trying to protect AI and think through what's the piece that's useful here. Some people will get to a point where they say, okay, well, gosh, the thing that we do that's really interesting and innovative, kind of actually doesn't have that much different than we applied some rules and we generated some data, and now you've got some output and a pretty report like that. We didn't really innovate all that much more. And then they have a really solid answer to all of the investors and partners and acquirers on the IP side. We evaluated our technology. We looked through all the functionality, and that is not where our differentiators lie. So we did not waste money on that. All right, I'm falling behind on questions over here. How about pricing? Do we mean pricing for how much patents cost? Is that what the question was, Rose? Yeah.
Yes.
Okay, and then the other question is, most AI patents fall under utilities. Yes, so the differentiation between different kinds of patents is pretty minimal at this point. You've got some plant patents that nobody that I know actually does. You've got design patents, which have a place in the world, but are less likely to be useful for artificial intelligence and pure software companies. And then utility just means you've got a method or a system, and that's where most AI patents fall under. In terms of how much it costs to do the patent application thing, man, it is brutal. Let's just get the nasty part out of the way, the bad news out of the way up front. Minimum $7,000 in the first 2 months that you're working on this, $21,000 over the course of the first year, and average cost over 6 years, probably about $60,000. So nobody's doing this for fun, and no one's doing this because they had nothing better to do with that money. And that, I think, is the biggest reason to keep going back and asking yourselves, what's the business advantage I'm getting out of this? Am I actually telling people that I have a patent? Are they impressed? Are they giving me more money because of it? I have 3 clients that actually have a bunch of Polish patents granted and in place because they had some investors that were super bullish on Poland. They were certain that Warsaw is going to be the next great big hot silicon area. And so, okay, they've got people that are willing to pay them for it. There's always a business angle to why you get patents and where you go to get them. You're always looking at, who would I license this to? What do I think my competitors are going to be doing if somebody sues me? What do I think that's going to cost? And is it worth the cost of having patents in place to be able to counterclaim or force a business deal? So the numbers are big, but you're probably also not getting a coder for $60,000. And anyone that's going into business is probably going to be looking at pretty big numbers, and they need to get used to the idea that this is a real business. I think that's actually something a lot of very tiny companies don't do often enough. It's not just you sitting in your coffee shop. You are a international organization, happen to be headquartered in wherever your coffee shop is, but think about yourself where you will be in 5, 10, and 15 years, and really think, what will you wish you had done back in the beginning? You may not be able to do all of that. You may not have the budget that you have now that you wish you had now, but make the decisions based on what you wish you would have done, or at least be aware of what your options are, so that you can be smarter about how you face those costs, and not penny wise, pound foolish, euro foolish. I don't know. So yes, unfortunately, it is expensive, and I think the biggest thing that we often say is tie it to a business reason. Why would you do this? You're going to spend $7,000 this year because you think you'll get that much out of it, being able to tell your potential investors you haven't blown your rights and that you have preserved all of your options while you're raising more funding. But it's a part of what I do with very early stage companies that come to me for their first filings. And I say, why again? Why do we want to do these? Not to talk myself out of perfectly good work, but let's make sure there's a good answer there. So that's that piece of it. It's our reality check. I want to pause. I know we've raced through a ton of information. Are there any questions? Types of IP, why patents, obviousness? Yeah.
Yeah, can I have a clarification on the new versus non-obvious thing? For me, that non-obvious thing is really hard to understand because, at least in my field, we've come up with some things that certainly are not obvious to other people in the field. And that's because they're new, right? No one would have done that before. And I've always had a hard time figuring out what the difference is. I mean, can you be non-obvious but not new? Can you be new but obvious, I guess? I'm not sure.
Most often you can be new and obvious. And the difference in a patent office, they for a company, for an organization that really focuses on words and language, they use words in a funny way. We constantly get final rejections. And I have to explain, that's not final. It just means you have to insert another quarter to keep playing. They didn't actually, they give you more options to talk to the patent office when you get your final rejection. They didn't mean that. So this may be an area where the language is not helpful. So in our world, the patent world, if something is new, it means they couldn't find anything out there that explicitly taught each and every element of your claim. If you had a claim for a wooden stool with 4 legs and it had a leather cushion, they could not find it. Obviousness might be, well, they found a stool over here that had 4 legs, and they found this one over here that only had 3, but it was made of wood. And they found this thing over here that's actually like, you know, a car seat that's got a lot of leather on it. That's kind of a seat. And they cobble those 3 together and say, to somebody of ordinary skill in the art who's trying to solve the problem of more stable and comfier stools, it would be obvious to pull these 3 things together. We've got 3 versus 4 legs. 4 is going to give us more stability. I don't know, let's say something impressive about wood versus other materials. And then the leather seat is going to be more comfy. So even that was for cars, technically, you know, it's still for chairs. We're in the same area. We'll pull it together. Something that we'll often see in software, we'll find a company that was doing something without AI. And then we'll find a patent that says, hey, AI is known. And we'll have to explain, yeah, no, those don't automatically get pushed together. We've pushed back a lot on obviousness because I think part of the challenge is it's obvious once you see it. Hindsight is always 2020. Now that we know about it, of course it's obvious. So part of the education that we have to do to the patent office is explaining why is it the case that this is actually not obvious, and people at the time wouldn't have known to combine those 3 different references.
Hey, Cynthia, before we continue, there's a bunch of hands up. Did you want to open up the Q&A, or was there more stuff that you wanted to talk about with AI and patents?
I've got, you know, a bunch more material, but let's go with the questions and make
okay,
sure
because we'll continue with the questions, and I'm concerned you won't get to the material.
No, that's fine. Let's.
Right.
I think I saw Rose's hand go up
All
first.
right, Rose, then Michael.
Thank you, Cynthia. Cynthia, I have a question. So if the patent process fail, is it possible to get money back or refund, or?
Love that.
Just
I love that idea so much. No, sorry. No.
Oh.
Yeah, so
Another question is,
it's a thing to think about. Is this, once you've invested in this, it's sunk costs, it's not coming back. And sometimes I have to tell clients, you know, if it was my money, I wouldn't. We're on our 8th, you know, argument with the office. We've been doing this for 6 years. I don't think it's going anywhere. That's an area where you kind of have to trust your attorney and have a good working relationship with them, because I try to be as data driven as possible. Patent office does not make that easy, but I am able to get some information about how many patents a particular examiner is willing to grant. So they'll have, it's publicly available, you know, Examiner Smith grants 87% of the applications that cross their desk. 87% of them will turn into real patents. Nobody throw up on him and we're going to be fine. We should keep fighting. If he's given us his 3rd rejection, it's not a big deal. Let's just keep going. He's going to get us this one. I've also had clients who have a 3.4% allowance rate with their examiner. Like that is almost like it's almost nothing. And I'll say to them, look, I've gotten that before. I've spent 6 years and a lot of money. I like a good intellectual challenge. I'm argumentative. I can get that for you, but it has to be worth it to you, the client, to all the while be able to say you're patent pending. You've got to get something out of it in the meantime. And so that's an area where really having an honest conversation with the attorney about what you're getting is important. Do you have a follow-up?
Yeah. Also, another question is the patent is covered only USA or internationally? Thank you.
Yeah, so we have a bunch of treaties in place to make it easier to file internationally once you have filed in the US, but your US patent is only good in the US. If you wanted additional patents, there's a whole timeline for how you pursue the international option. Yeah.
Thanks,
Michael?
Michael, and then Victor.
Oh, thanks. It kind of quick because we're on this topic. That's why I wanted to go with it. Is you mentioned utility and usefulness, and especially people now that we're in this startups mode where everyone thinks, I'm sure they've got a great idea, and then of course you explain the money, which is an important sort of constraint. But in terms of utility and usefulness, it's sort of like, how do I prove that if I don't have a customer yet? Does that
You're never going to get challenged on that. Like
okay, that part is not an issue. Okay.
No. And I can't think of a client who doesn't think that their invention is super useful, is going to change the world, right? So most
I just thought to myself, well, maybe someone could make that argument, like, well, how do you know it's useful? You don't have, no one's telling you it's, it's sort of
no, that one's pretty good.
Yeah. Okay.
Yep.
Thanks, Michael. Victor.
Victor?
Yes, Cynthia, thank you. Just briefly, you mentioned a phrase, ordinary skill in the art. And as an average person, I can interpret that a certain way.
Yeah.
But if I'm in a high-end area, like scientific research, medical research, does the game change in that definition? Because ordinary skill is pretty darn extraordinary when you're researching blood disease or cancer solutions or that. And does it become, well, you're in the game, you could have, but you didn't discover it, I did. Is that the new standard when the ordinary skill is extraordinary?
Not exactly, but ordinary skill is definitely a shifting, moving target depending on what area you're in. So certainly I've had clients who are like, listen, this is very straightforward. The standard or one of ordinary skill in the art, we often say is, well, a well-trained up intern, a rising junior in college who studied computer science, maybe some electrical engineering, they're pretty good at what they do. If you set them out to go and start coding something up for you in the morning and they finished it without any problems in 2 hours, maybe not that innovative. If you told them to go solve the problem and they came back 3 weeks later, and they were of ordinary skill, not that they were just slow, then maybe we've got something to talk about for an invention. There are other spaces, especially in the life sciences, where everybody's got a PhD, and that's the standard for ordinary skill in the art. If there are particular either terms or concepts that are really important that one of ordinary skill in the art, one of your peers or competitors would definitely understand a certain way, and you're trying to keep that definition or change it, that's something you usually explicitly write in your first filings. And then it becomes something you can fight about with the patent office and anybody you're litigating against later. But it is a shifting target, and it does depend a bit on what area you're in. You don't usually have to specify that though. It's not like we're required to say, here's the resume for somebody that then we're going to attach that exhibit A.
I think I got the gist. Thanks so much.
Yep. Kelly?
Yeah, Lee.
Yeah, hi. I apologize. I had to take a call right in the middle of your talk, so you may have spoken about this. I'm curious. I've been involved in a few legislative discussions in Washington, D.C. about the IP theft issue in China, especially. How secure, once you get your patents, how secure is that actually, and what recourse do you have with other countries that and bad actors in other places that might want to take your stuff?
Yeah, it's definitely a challenge, and I would say it's gotten better in China over the last 20 years. Probably 2004, 2005, we would ask our foreign associates, so why are we filing these in China? Are they actually going to get enforced? And they'd say, well, it's really a good idea. That was sort of the end of it. Probably 2010, 2012, it got a lot easier. If you have a subsidiary in China, it got a lot easier to, you had actual boots on the ground. You could take them to court. You had local counsel, you had local business, local everything. It became a lot easier to try to enforce it. And then the last 10 years, 5-10 years, we have heard it has gotten easier again, if you have a local company, to enforce it, you know, go through the litigation process, get an actual judgment, and get that actual damages or whatever enforced. Now, you have to be of a certain size company to have your operations inside and outside of China, and you have to have a fair amount of finance to put to this. And I think it's less of an issue on the software side. People that are churning out widgets, like actual physical stuff, they kind of don't stand a chance, right? But it's a little bit easier. I think what's interesting in China is that we've been hearing from our associates that they are more likely to encourage Chinese applicants to file outside of China. So right before the pandemic, there was a program where they would pay the patent office fees and the attorney's fees for Chinese inventors who wanted to file in the US and in Europe. So they are certainly much more interested in getting IP rights elsewhere. I don't have enough clients that are active in China at this point to know. I've had 1 or 2 that have gotten things enforced, gotten licensing deals in place. It's all very anecdotal, unfortunately, not a lot of great data, not a lot of visibility. But generally speaking, it's not just China. You're going to have this challenge if you're trying to enforce something in another country. We can get you patents granted in Europe, India, Japan, South Korea, wherever you want, but if you're actually going to enforce that, you're going to need to know people are infringing it. You're going to have the wherewithal to hire local counsel and go after the process there. So it's a big company thing to do. It is not. I think for startups, the best thing to do is really think through, honestly, like, what are the odds that you're going to actually set up shop in Argentina? Because the process of getting your documents signed alone could bankrupt you. It's so difficult, much less actually hiring litigators and going through that. So how much business are you going to lose there? How much business are you actually going to lose in whatever country, and how serious are you? It's
the gentleman I spoke to was the founder of iRobot, who had the Roomba. And he said that they literally took his Roomba. They took it apart. They put it back together again. They filed their own patents that were later than the patents that iRobot filed, and then sued Roomba or sued iRobot to enforce their patents with the strategy that they couldn't outlast or outpay. The Chinese, which is basically a government company. And fortunately for him, he had enough money to go through the process. But they said that part of the strategy is for the startups and for smaller companies is they just can't afford to fight it. So they end up losing their patents over there. It sounded like a very distressing, sort of thing and I don't know if the US government is actually doing anything about that or how as the legal profession is handling that. But you're saying it's getting better. That's good news. So thank you.
It is, but quite honestly, that's a problem in the US as well. Right. I can prepare your patents as best I can. I have recently had 3 patents get granted by 5 different patent offices around the world. And they have gone through additional judicial review here in the States, the Patent Appeal Board, which is surprisingly patent unfriendly, and all of them stood up. And I can do a lot of work to turn out amazing technology patents. Mm-hmm. But if the client doesn't have the money to go through that, the first thing that's going to happen when you sue a giant company who has so much money that their founders off curing malaria and creating new educational platforms is they're going to say, sorry, you didn't actually get a real patent. We're going to have to do a couple $100,000 worth of work at the patent office. You're going to have to fight us on that. And maybe you have $600,000 to $1 million to do that first step, and maybe you don't. So even here in the US, it is much more valuable in terms of hoping you can get yourself to a positive business solution, hoping you can say, just cross-license. You don't want to waste all that money. We're taking your market share. We're doing all these other things on the business side. Just do a deal with us. And you're kind of hoping they don't call your bluff, because if they do, you may or may not have the money to move forward. And I try to prepare clients as well as I can for that eventuality. But a lot of the questions I ask is, what kind of people are you competing against? Are you competing against people that you're regularly hearing in whatever the trade headlines are? They're litigating all the time, or are they doing deals and acquiring people? Or are they entering into partnerships? Can you get a sense for what kind of people you're doing business with? Because that's true in every country, unfortunately.
And patent trolling was a big deal, at least I know, about 10 years ago. Is it still the same? Is it, do we still have a lot of that?
You know, patent trolls are such a funny phrase, because it conjures up all kinds of nasty images in our minds, right? We immediately go on the defensive. I don't want to be subject to some kind of a troll. Yeah, but you know, from a certain perspective, we all know giant universities that do nothing but create technology. They have no plans of ever turning into real companies. They're going to license it out. They've got whole offices set to go extract money from people. Sure, we'll let you have this IP if you give us a ton of money. So I think that there is there are a lot of people that and organizations that fall under the umbrella of patent troll. Some of them, I think, just got as far as they could and would like to get a good deal back. They're not getting their $60,000 or $70,000 back from the patent office. So they would like to try to sell this to somebody who could give them a reasonable business deal. Some companies will actually create a play for a particular, they will target it and say, I don't know, dear iRobot, we have like these 3 patents and we think this will be useful given your new feature set or that new competitor that you've got. You should do a deal with us. And sometimes the only way to get iRobot, not just to pick on them, any company that's big enough to get their attention, is you sue them first, and then they have your attention. And then there are companies who say, okay, well, now you're making lots of money. They're the actual trollish companies are very unlikely to go after a pure startup because those guys don't have any money. They have nothing to shake them up for. Yeah. So it's not until you're actually a significant player that you're likely to get those kinds of letters. And then for that small percentage of people, then there is a question: how do we deal with this as a business? Is this something that we're just going to pay them off? Is it something we're just going to have a line of business, a line of expenses in our annual budget? This is how much we pay trolls. I've seen all kinds of approaches to it. A lot of companies have said, we're just going to sue. Cynthia, we don't even want to file any patents, but any troll that comes after us, we will take them down. We do not want to pay any kind of ransom, essentially. So that is one where, again, the company has to do some significant soul searching and decide what the business thing that makes the most sense for them is.
Got it. Good luck, Tom Bellatori. Good luck, buddy.
Thanks. Cynthia, before we call on Roland, I just want to check in with you, make sure we're on time. We're okay with the other stuff that you want to talk about.
Yeah, I've probably got about 10, 15 more minutes before I have to head out, and I'm happy to do questions.
Well, so did you have more material about like the, uncharted territory of AI?
I think I've got the main points across. If anybody wants to chat further, I'm always happy to. I could always come back and do a part 2. But
careful, we might hold you up. We might do that.
Excellent.
Thank you for that. But so Regina put in the Zoom chat a wonderful question. How does a company monitor infringement on its patents?
So this depends a little bit on your size and what your appetite is for picking a fight. And most people are aware first that they have a competitor and then that they have an infringing competitor. So usually by the time someone says, oh, geez, do we think they're infringing? They already know about this other company. Often there's some kind of an emotional connection. They advised me on my PhD and they've always been jealous of me. And that's why they didn't buy me out when I went to their company. And now they just released this product that's super suspiciously close to mine. And we have to sue them for every penny. This is terrible. He's been taking advantage of me for decades, right? There's some kind of a story, but usually there is a personal connection between two companies. You have been competing since you were both in, I don't know, Techstars or Y Combinator or the Engine or whatever, and you've always hated each other. Usually you know who your competition is. And then it occurs to you to say, that's interesting. They seem to have come up with a feature that's just like the one I talked about, last month at the big trade show, or that I told them about when we were going to consider doing an acquisition. So I would say for most companies, that's how it comes up. There are certainly companies who say, I want to monitor, I want an alert that tells me every time somebody cites one of my patents, because that means they're filing something that's kind of close to what I'm doing, and maybe I should do more research on them. There are companies that regularly, and usually these are bigger companies who are actually going to take on the fight and actually going to go and litigate. And that's, you know, a $10 million project to start with. So usually bigger companies have all these plans in place for figuring out who's using our technology, who's interested in it. At the startup level, the best thing to do is really just keep an eye on competition and talk to your attorneys about how important is it to be monitoring who's releasing what kinds of features. I've had clients who are like, every 3 months, we want you to go to these, 12 websites and just tell us if they've got anything that looks like what we're doing. Other clients are happy to just set an alert and see did they cite our materials in anything that they filed at the patent office. So there's not a one size fits all super easy answer. We get the lawyerly, it depends, but usually there's a drive from the business side to find out if someone's infringing. It is actually also a really important question to be thinking about when you're filing your patents, because you kind of want to be able to know from public materials if someone's infringing. So if we filed a patent that said, and all the servers on the back end are Fuchsia, well, they're not going to market that. It's not going to be on their website. So what are you going to do? Storm the place and try to figure it out? You're going to tear open the box and see what they've actually got back there? That's part of the decisions that go into figuring out how we define invention and whether or not that's those claims are really creating the best and most enforceable patents that we can be.
Thanks for answering that. Roland, your hand is up.
Okay. Thank you, Cynthia, for the speech. And I got 2 questions. One is like is there a global patent institution at this point? There are none, right?
No, we've just gotten to the point where there's about to be a unitary patent in Europe, where you go through the process once, and for the European Patent Organization, you get one patent. That is brand new. That is getting rolled out this year. So we are really very far away from a global patent.
Okay. Oh, okay. Thank you. The other question is, for the like normally when we ask about a patent comparison, like for 2 patents, if it's filed at a different time, one is filed based on the improvement of one patent, the other one is brand new came out of patent. It's always left for the patent office to decide which one, like if there is any conflict, or like is there any conditions that you guys deal with, like as in the, for some reason both of them are filed and then it goes into conflict? Is there this kind of scenario actually happened before?
I'm not sure I'm following. You mean if 2 companies have filed patents at the same time, or do you mean how is the patent office evaluating 2
Because
patents?
Based on my understanding previously is that the patent can be either improvement of an existing patent or it's a brand new patent, right? So was the patent's value, like you may mention earlier, but was the patent value based off the application, like, or the theoretical that branch it came out of?
You mean, is it worth more if you have a patent for a completely new space?
Well, like the thing is, at some point, if the 2 companies going into the conflict, based off each of them holding a patent, and one of them are completely innovative solutions, the other one is based off their existing solutions, but both of them targeting. Is there a possibility, and under the case, how it was handled?
Yeah, the difference is it's not going to be looked at that way. If they're trying to decide which patent is filed first, is something they might look at. If they're going to evaluate which patent precedes the other one, they're very unlikely to say, well, this patent is worth less because it's just an improvement. That's not likely to be the analysis. Usually there's either a fight over who filed it first. If it's old enough, it's who invented first. But for most patents these days, it's who filed it first. And that's going to be affidavits and pulling discovery data. That's never going to come up from the patent office, by the way. That is only going to come up in a litigation situation where one of them has a lot of incentive to try to figure out what the other one did or didn't do. But it's not going to be based on how good the invention was or how different it was usually.
Gotcha. Yeah, I think that's all my 2 questions. Thank you very much.
Sure.
Thanks, Roland.
Time for one more. So
Well, I've got a question.
okay.
If that's okay, before we get to Victor, I don't know how much time we've got left. So I would love to know what your thoughts are about copyright infringement. I know we're supposed to be talking about patents with these generative AI models. So Stable Diffusion, Midjourney, GPT, these are trained on information that was scraped, arguably, from the internet. So this is infringement by my understanding. I put an image up there, it's on the internet, somebody scraped it, they've copied it. They've trained a model with it. I see this as fair use, however. What do you think? And I'm basing that off of what were the 2 cases with Perfect 10 versus Google and Authors Guild?
I don't actually follow those
Okay.
kinds of cases that much, but I think there is going to, there was recently a fair use case. I think this is something that's going to have to get fought out a lot. And my guess is that real artists are going to lose just because they always seem to lose.
Okay, good. And I'm an artist, so yeah.
That's fair or not, but that's how I'm seeing it. Technically, I think if I put my image out there and somebody scrapes it and feeds it to something else and creates a derivative piece of art, whether it's using pen and paper or using AI, that's a derivative piece of work based on mine, and that's an infringement. Fair use is actually pretty limited, right? There's no fair use because you're like doing it for a good cause. There's no fair use because you're a nice person and we should let you.
But it's fair use because it's transformative. And like if the output of that model was, again, the model was trained, weights and biases are implemented in that black box. Yet when I prompt the model to output something that was trained on my image, trained on my book, trained on my text, the output has nothing to do with it. And it would be hard pressed to find
the
out.
right to use that image in the first place.
That's the infringement.
What gave you the right to use it?
There was no right given. That's the infringement.
Yeah.
But
So
is it fair use?
No, fair use is very limited, right? We've got some parity. We've got some very limited educational, super limited. Fair use is not as delightfully broad as everybody would like it to be. I also don't think we're at a point yet where AI is good enough. I think eventually we'll get to a place where maybe the AI can create or take from publicly available images just the pieces it needs to be trained up. I think maybe we can get to a place where I don't know. I think right now it's not fair use and somebody ought to be getting it.
If it's not fair use and these pending lawsuits against these large companies, the Supreme Court's going to have to weigh in on this. And if they say it's not fair use, these technologies go away in the United States overnight. So how could they not say it's fair use? Or are they going to have to rewrite new laws?
Well, we know that the Supreme Court hates bright line rules.
Yes.
And they hate technology. I think pretty fair to say they either hate it or they're terrified of it, right? They don't even have email addresses. They're like not allowed or something. So like, it terrifies me that these are the folks in charge of making really important decisions for us. But I'm guessing if it came to it and they really were forced to, they would probably make some kind of a decision about what the definition of fair use has traditionally included and try to broaden that where to the extent possible. I think they'd probably dodge it until it was clear that there are different parts of the US that are viewing this differently and that there's a real fight between federal courts. And then they'd say, fine, okay. I think they would probably dodge it as long as they can.
I'm emotionally torn by this because I'm an artist and my friends and my students are artists, yet I'm also an AI practitioner and I see this as infringement and also potentially fair use because the output of the model, what the training process was the infringement, but what the tool has done is fundamentally transformative. And that's
but what was fair about using it in the first place?
Nothing. I mean, because they did it. They did it anyway. So yeah. Anyway, thank you. Victor.
Yes, I have to ask, are we over time or do you have room for one more?
One more question.
Okay, this is not too deep, but you used the concept of describing what your idea is and how it works. And there's a line that you can cross which kind of eliminates you from patentability. If you put it, I used to hear the term, if you put it in public domain. But
Yep.
I want to narrow the question to startups where you have something, you're looking for family and friends, you're looking to get the attention of an investor, you're looking to win a pitch competition, you're in an accelerator program, and you have to give, in any of those circumstances, a bit more of how it works to prove the differentiation, to gain the investment or to gain the attention. At what point have you crossed that line in those environments?
Yeah, this is a brutal part about the process. How do you create buzz and raise funds and get off the ground if you can't talk about it? And how do you pay to get something on file if you don't have money because you haven't talked about it? There is unfortunately no really good answer here. Pretty much anything that you do that is a public discussion of the invention, the US is going to hold against you, and they're going to say you get 1 year. And so you've got a grace period in which you can file. And international patent offices are going to say, it doesn't matter if you actually disclose what the invention itself is, then you've lost your rights instantly. So the most straightforward thing is to figure out a way of being able to file your patent application first, find some way of pulling together resources to do that. The next best thing is to try to figure out if you can file it yourself. There is a version of the application called a provisional application. And obviously you ask a patent lawyer about self-filing, and I think that's a dumb move. And I got 5 nightmare clients I can tell you about who are really sad they tried to do that, but you know, it's a reality that they can't necessarily afford it, and they'll do their best. The next thing to do is decide how important is the international piece, because you could just say, well, we're going to disclose this in the US and we're going to file within 1 year. We're going to take careful notes of who we say what to, and we're going to make sure that within 1 year from that first discussion, we file our US application. And we're going to save some of our features. We're not going to talk about every single one of those features so that we can go off and do a second filing later. I see this comment asking if a pitch deck sent to an investor is considered confidential. It is absolutely not confidential. And the biggest way to embarrass yourself in front of an investor is to ask them to sign an NDA. It'll get you kicked out so fast, right? So unfortunately, it is not confidential. But you do have the 1 year grace period. And so thinking seriously about, well, am I okay with that? Is there some subset of features that I could say, these are the ones I'm going to talk about and these other ones aren't? And again, that's why I said earlier, it's never too early to talk to an attorney who can help you brainstorm what's the best way of handling this, so that you're not scrambling a year later trying to figure out what you did or didn't do and what you can still protect. And I think there is a challenge here too, because the patent office is never going to ask, what did you disclose? They're going to assume that we've done the right thing. They're going to assume that we've told them about everything that's possibly relevant, but they're not going to dig into this. So when it's going to come up is when someone's doing due diligence on you, right before some really important event for your company, the big funding, the big acquisition, the big whatever it is. And someone else is going to be incentivized to find all of the reasons that this was terrible. You and your co-founder split months or years ago, and they're off in Hawaii somewhere, and they have no reason not to tell all of the people that you talk to and all of the investors that you shared that to and when, and maybe the other side will pay them for that, right? So it will never come up in a very nice, pleasant, friendly way. It will always be at the most inconvenient time for the company. Figuring out your plan ahead of time is really the best possible thing you can do.
Fair enough. Listen, thanks for that. And
it's not an easy answer. That there's no
no, it isn't. It isn't,
work.
especially when you have a scientific breakthrough.
Correct.
That is worth a lot of money. But thanks for coming to talk to us, and thanks for your answers. Appreciate it.
Absolutely. I have sort of a cheat sheet on the different kinds of IP and when you should be talking to different kinds of lawyers, and sort of patents 101. If you want to put your emails in the chat session, I'd be happy to send those out to anybody who's interested. And certainly feel free to reach out anytime you'd like. I'm happy to follow up, have more conversations.
Cynthia, thank you for this.
Excellent.
This was really, really, truly priceless. I would love, I'm really tempted to take you up on that offer to come back, because
Sure.
thank you very much. Susan, did you want to I'm cold calling Susan.
Yep. Yeah, absolutely. So Cynthia, thank you. It was great. And there is a lot more behind. So we may want her to come back and talk some more about it, but you get a flavor now that it's not simple and not easy, and a lot of things to think about. So thank you, Cynthia, for coming. It was great. And it was great to see you.
But it is simple. It is easy. We just need to hire Cynthia, and then all the problems go away. Right. And then, right. Problem solved. Before I end the recording, again, Cynthia, thank you very much. I just want to remind everyone, next week we're not actually having an HBAP startups meeting. We're doing the HBAP social. That starts at 8:30 p.m. Eastern time. July 12th is Phil Morris, the entrepreneurship of acting. July 19th, we're going to be doing a generative AI workshop. And then on July 26th, Congressman Jimmy Gomez is going to come to talk to us about AI regulatory complexities. And Cynthia, you're welcome to come join us.
I would be very interested in hearing
Yeah.
that. Really, yeah.
Please join us for that. I will add you to the newsletter. Thank you all for coming. I will see you guys next week.